There is smoke.
Well, because the fees are the big issue, we might as well start there, huh? As you guys, as the commission will see, or written comments, and I won't read them all entirely. There's a typo at the bottom of page 2. The original suggestion was a $500 flat fee for a commercial permit application. We were agreeable to a $1,000 fee for a commercial permit application. I want to reiterate that a couple of things. One, the amount of the fee should not be tied to the cost of the development. There's no basis for that. There's no reason for that. I understand the county is trying to adopt some stuff from Harrison County or wants to adopt some stuff from Harrison County, and they want to have some basis to come up with a number as to what fee to charge. Under the law, fees for permits have to be reasonably related to what you're doing. And a $1,000 permit fee is probably the second highest permit fee that the oil and gas company has to pay as part of the permitting process. I recognize that some of these smaller fees for additions to your homes and things like that should be lower. I don't have any problem with that. I mean, you know, if you're just building a little bit on your back room or something like that, I have no problem with that. You know, pardon?
I was going to say, could they be related to the cost of the project, maybe?
Well, what I'm saying is there's no rate, there's no basis.
$100,000 house compared to $4.5.
There's no basis for that. What I'm saying is there really is no basis for that. There may be on a level of some smaller project, but once you get to a certain $100,000, let's say $100,000 development or above, it should be $1,000. I mean, there's really no reason that for every $1,000 that the project is over $100,000, you got to pay an extra $5. There's just no reason for that. So if you look at the fee schedule, the paragraphs, or the sentence lines underneath the categories should be stricken. They should be flat fees. I would like a clarification from perhaps Mr. Wellings or the commission or whoever is proposing this location permit fees at the bottom. The fee for drilling oil and gas well, $1,000. Two questions on that. I'd like clarification before I respond further. Does that mean for a Marcellus pad or each well on a pad? Because quite frankly, the constructions will be the same whether you drill 2 pads or 4 pads.
Does the DEP charge a fee for each individual well bore?
Yes, but the difference in this scenario is you're taking a certain part of the area, and whatever disturbance you have in floodplains will be the same. It shouldn't matter any more or less. The project is the project. So we asked.
Yeah, it's still the same. I mean, you got extra equipment coming in for each well bore to drill it, and so it's each bore has its own baggage with it.
But the development, it's one development. It's one development. And then the site plan would say here we're going to have so many wells. I would submit that it should be a flat fee for a well pad. I would also ask for clarification because there is some ambiguity in this fee schedule that for new industrial structures or additions or renovations to existing industrial structures, changes in land use and land altering activities for industrial purposes is $1,000 plus $5,000 per acre, or $5,000 per 1,000 in cost in excess of $100,000. Mr. Tennant and I had a phone call trying to figure out how much an application permit fee would be, and the calculator doesn't always work to come up with the number. I think the number is if you're doing a $20 million project, it's a $100,000 fee. I'd submit to you that a $100,000 fee, any way you shake it, is going to be unconstitutional. And I can submit to you and represent to you and almost promise you there will be litigation of that issue. And that's not a threat. That's just whether it be my client or someone else. I can tell you that the industry as a whole has issues with that. Yes, ma'am.
Well, if you don't like the fees and fines, couldn't you just have somewhere else?
Well, that's one way to do it. But you also have to understand is these fees and fines don't just apply to us. If you want to build, someone wants to build a $500,000 house, it's going to be an elevated fee. It's not just going to apply to us. The other alternative is, with all due respect, the other alternative is because it's unlawful and unconstitutional, is exercise our legal rights and challenge it that way, which is going to be more delay on this ordinance. This will cost more time and money for the commission, and we'll be back here again. So we submit you to it right.
And
look,
here you're worried about spending a little fee money and you're gonna go to court? Oh, come on.
let me make my comments and I'm happy.
We heard your comment.
So I would submit to you that the fees amounts should be capped at $100,000. Anything else is just going to be not related. You know, you can talk about Mr. Wellings and it's a full-time job. I don't know what Mr. Wellings is getting paid. I don't know what his rate is. I can tell you that at $1,000 per well pad and other developments, it's going to be more than enough to cover the cost of the permit processing. $100,000, and all you folks can be driving some nice new cars. Because if it's $100,000 per well on a site, and we can spend $800,000 for a permit.
We're only talking about the floodplain, not anywhere else.
It could be absurd.
That's where the risk is.
It could be absurd. With all due respect, man, you have your
Wait a
chance.
minute, let him finish and you can.
So I want to make that, I can't emphasize that enough, that issue. And I think that needs to be clarified. The other, because if you do it in excess of the reasonable permitting fees, the reasonable expenses required, it is an unconstitutional tax. And you do not have the authority to assess a tax under Article 9 of West Virginia State Constitution or any of the provisions of West Virginia Code. You cannot assess a tax, and it would be an impermissible tax. There is also an issue if, for instance, we would drill a well, and we would have 6 tanks on the site. We may need to add 2 additional tanks on the site because it's producing a sufficient amount of, an excess amount of brine or condensate or whatever it would be. Well, under the ordinance, we'd have to apply for a new permit, we'd have to pay all these fees again, and go through the entire process when it wouldn't be necessary, we would have no further disturbance other than what's already there. So there needs to be some consideration of that. We did look at other jurisdictions. I've researched floodplain issues all across the country. You guys know I've been in this case. I've researched lawsuits against county commissions, cities. I've researched language of floodplain ordinances, fees, penalties, all those things. We have found support, and there is the opposite for flat permitting fees, so we think that's reasonable. The next issue on fees really pertains to expenses, and I've kind of said that today, so I don't want to beat a dead horse. The issue with expenses are we have no problem paying for service fees, publication fees, things like that. But there's not always a time when there's going to be a more thorough technical review, I'll call it. I'm assuming that Mr. Wellings is going to look at this carefully and see whether an applicant complies, whether it's the gas industry or a resident. But the requirement to deposit $5,000 for money that may not be paid shouldn't be there. You know, you, ma'am, I think we're the one that brought up the question about you would have to deposit $500 if you want to do something in your floodplain. I don't think that's justified either, especially when none of it may be necessary. Some of the expenses may be incurred by the county through no fault of the applicant. Since I'm representing EQT here, if we file a floodplain permit application and Dan Welling says it's okay, and the county, and then we'll use Mrs. Huff since she's been picking on me, she objects and appeals to the appeals board, we shouldn't have to pay for those costs. I mean, she shouldn't have to pay for that. That's what she wants to exercise those rights, and vice versa. I mean, there should be considerations for that. Because while we recognize the rights of people to object and exercise their property rights and their property interests, we don't want to create a situation where every floodplain permit application is going to be objected to, and Dan has to go hire a consultant, Don has to come down from Wheeling, you guys have to have a hearing, and we have to go through that. Now, I'm not sitting here to tell you rubber stamp every application. I'm telling you to do it right, but we also need to make some caveats in there. I mean, there is no provision to dispute the services, the cost of it. I mean, just because you hire Don Tennant, that's fine. Don doesn't necessarily need to go hire the biggest law firm in New York City to fight this floodplain permit issue. So that's maybe not reasonable. You may go hire an engineer from India. It may not be reasonable. So there's the ordinance as written gives the county a blank check to spend whatever they want and just say, you got to pay for it. That's not reasonable. There's no way to dispute that. So I think there needs to be a provision for that. Again, we are willing to pay, and we have moved our needle to $1,000, which we think is more than reasonable. We didn't come here today and say it should be $500. but we think it should be that. If you guys have any questions, anyone else, I don't know if you guys want to make this a question answer, or you just want me to make my comments. I mean, it's getting late. You just want me to make my comments?
Yeah, make your comments.
Okay.
Steve, while we're on fees, can I make a comment regarding fees, or would you prefer to allow them to keep moving on?
Are you done, sir?
On fees, yes, sir. I have more comments.
Let's go ahead and introduce, go ahead and make your comment on fees.
I would just like to simply note, I would reiterate some of Steve's comments with regard to the fees. And I would also point out that, county commissions are creatures of statute, meaning to act, you have to be authorized pursuant to the West Virginia Code. And the West Virginia Code and the provisions that allow you to enact legislation regarding floodplains do not allow this county commission to enact legislation which would allow you to extract permit fees and expenses of this unlimited nature. I think I would agree with his comment in that you are allowed to extract a flat permit fee, but I would also agree that it has to be reasonably related. But I do not believe that with regard to expenses and other things of that nature, that is permitted under the West Virginia Code. That would be the only thing I would add to his comments regarding the fees and the deposit of expenses provision within the current version of the statute.
Yeah,
I'll leave it at that.
And I think that as to my comments is, I could say to you that there's no specific provision to allow you to charge any fee. We're not here doing that. There is no constitutional authority, statutory authority to allow you to charge any fee. What I'm telling you is, in order to stave off a challenge, a legal challenge, there needs to be some balance and needs to be reasonable. Because that way there are no issues. And that's our concern. I mean, look, believe me when I say this, I said it earlier, and people may not believe me. We want to get an ordinance enacted and start applying for floodplain permits and get drilling. We want to get a good ordinance. We don't want to have to fight with you guys. We don't want anyone else to have to fight with you. We know someone just sued you. Hopefully this ordinance can get worked out before you even have to do anything on that.
It's just that it's getting late, and I think that we should maybe alternate speakers. I mean, he'll probably talk for an hour.
I don't plan on talking that long. I'm trying to make.
Excuse me. Let me answer that. We're all here for the people in the county to hear what's going on. Everybody here has the right to speak, okay? Whether he takes an hour or he takes 2 hours. We're sitting here listening. We're trying to work this out, okay? I understand. People are getting tired, okay? I'm getting tired myself. So let the man do his job. We'll let you people do your job. I think we have let you do your jobs. Okay? This is benefiting everybody.
Thank you, and I'll try to be brief. And my comments, although they have a lot on their paper, some of them we're not going to talk about because Mr. Sneed basically told me I can't ask for those kinds of things, so we're going to take care of that. The next issue, and I touched on it earlier, is timeframes and appeals process timeframes. It needs to be clear. Right now, it's 90 days for dam wetlands to make a decision. That's too long. We submit 45 days from the day of application, more reasonable time period. And I know Dan's probably busy in his personal life and professional career, but quite frankly, everyone, including homeowners, really needs a decision quicker probably than we do. I mean, there are a lot of things you may want to do at your house in the summer. If it takes 90 days, summer might be over and you can't do it. So I mean, the 90 days is too long. We submit that it should be 45 days. Another, when this does affect all three of you, assuming you're going to remain the appeals board, which I think that's the way it's crafted, there's no provision as to when you must give a decision and how your decision is rendered. We submit that consistent with other rulings, and Mr. Tennant was kind enough to be involved and kind of gave a detailed ruling last time, and Mr. Robinson, you weren't here, so you didn't participate in that. We think there should be findings and facts and conclusions of law, especially if there's going to be some appeal. Mr. McMahon and I, I'm sure, would love to have reasons for the decisions of the appeals board. So I think that's a no-brainer. We can all agree to it. We think 15 days should be good enough. I mean, you have a meeting every 2 weeks. You can have the decision written out. If you want to go even further, there are provisions in code as to when and how detailed findings of facts and conclusions of law can be. I'm sure Mr. Tennant can give you guys some legal advice on that. It is a scenario that it could be up to 200 days. I did the math. If Mr. Wellings receives an application on January 1, the next county commission meeting isn't for 13 more days because they had one on December 30th and 31st. That's 14 days. There's more time for a comment period and objections, and there's additional time to rule in the appeal period, which notification. I mean, I could go on and on. 200 days before you guys even have to make a decision. That's not, if we want to talk about due process, that people's rights aren't being pushed forward by taking that much time. So I think we need to tighten those up. With regard to some different specific comments I have, my comment number 1, Mr. Sneed addressed, and I thought he said it was okay, so we don't need to address that. Comment number 2 deals with page 3, section 2.2.A.2. It deals with cumulative impact on the base flood elevation, which I don't have a problem with the concept of it, but it's not, cumulative impact is not defined in the ordinance. I would submit that cumulative impact is defined, as I've written, and I'll read it for you guys, to mean the total impact to the 100-year base flood elevation as a result of any previously permitted development under this ordinance and any planned development. The planned development is defined in the ordinance. The reason I submit that is I don't know all development that's happened, which I don't think there's been much in this Huff's Meadow that we were fighting about, but in particular floodplains, you don't know what all development was there before. So it's impossible to determine what the base flood elevation is. So we submit it should be as of the date of the ordinance and all permitting moving forward, because a properly permitted site plan, and if there have been floodplain studies, are going to set forth what the base flood elevation is. It's easier to do the math and people know. Without that, there's just no way of knowing.
Mr. Hastings, I'm sorry. You said page 3?
I think it's under it first comes up in the definition of adversely affect the subject or adjacent properties.
Right. Okay.
The word cumulative impact is in that definition.
Okay.
And so my comment really isn't about that definition. It's about the need to define cumulative impact and what that means.
Okay.
And your suggestion is to define it as of the date that the ordinance is enacted, because the problem is that because we've not kept track of the permitting, that one couldn't see what else was granted within that floodplain area.
Yeah, so you can't really quantify the cumulative impact. And I can tell you, with respect to base flood elevations, and we talked about the engineers earlier, our engineer and Joy Huff's engineer had differing opinions as to what the base flood elevation is.
Yeah.
So it's difficult to determine what a cumulative impact may be in that regard. And I think that helps. That's not an industry thing. That's just clarifying thing.
Just look around and see what's already there.
Well, yeah, you could, but you don't know what impact that had on the base flood elevation.
Exactly, because one of these areas, especially Zone A, has never had a study done.
Now, if there has been a base flood elevation delineated by FEMA or mapping or something, we could put a provision in that would be the initial base flood elevation.
There you go.
But there had to be a caveat that there was no other development in there. I mean, it just needs to be defined a little bit better. My next comment is just a lawyer in me on page 17. Cumulative effect should be cumulative impact, just so we're using the same words throughout the ordinance. My next comment deals with the definition of floodplain administrator. I think Mr. Sneed, we beat that to death. Is that fair?
Good.
The next comment dealt with reasonably safe from flooding. Mr. Sneed killed that one, so we don't need to talk about that one.
Let me say on that one, I had the same reaction about those words at one point in reading the ordinance, not this last time. I think I might even mention it to you, that it seemed inconsistent to use those words, but I neglected to realize that reasonably safe from flooding is defined in the definition section, which made my use of those words, which are really FEMA words from the original FEMA ordinance, I felt more comfortable using those words than using a bright line definition like you're suggesting.
Yeah, my rhetorical question in my comments is, could a development cause a 2-foot rise in the base flood elevation and still be reasonably safe from flooding. That's a possibility. Well, no, but it could, under the definition of reasonably safe from flooding, as opposed to rise of basement elevation. I mean, that's we don't need to get into that. You've already answered that.
Well, that's why reasonably safe from flooding should be defined as equal to the 1 foot rule.
That's we're proposing to make it a bright line. You could add that to the definition.
And I understand, I think we agree on that, and the problem is getting FEMA to agree on that.
That was my next words.
Well,
I don't think they will.
And I think this, Dan,
Talking about a book.
I don't know why they won't, but
and I'm assuming if I submit a floodplain study that says there's a 1 foot 6 inch increase in base flood elevation, Dan, you're going to deny it. Is that doesn't matter if we still have someone saying it's reasonably safe from flooding. That's probably a way that it's going to be in practicality. My next comment is on page 19 and 20, which is a requirement to produce a contract as part of the application process. And I don't know if this is specifically a FEMA issue or a county issue or not, but there are several issues with that. One, the contract itself has no basis to whether a floodplain permit should be granted. The contract itself has no basis as to the fee for a floodplain permit. In my client's world, contracts aren't always entered into at the time of the application process. I mean, we might hire an engineering firm to do a floodplain study and do the permit application. We would go through the DEP permitting process, Army Corps of Engineers or whatever else we would need, and then only after we know we're going to get the permits, we would send out for bid or do that. We don't always enter into contracts that specify the amount of work. And we have agreements with companies, obviously. We have situations where there are purchase orders. Is that an agreement? Is that a legal contract? Yes, but that's not the contract contemplated by the code for licensed contractors, which is anything over $10,000 supposed to be in writing. There are provisions in our service agreement that we can't disclose unless by court order or by agreement. So that's another issue. I mean, we do appreciate the prior comments about confidentiality provisions and things like that was added in, but we don't understand, we haven't heard why the production of a contract is necessary.
well, it relates back to the fee, obviously.
Okay, well then, that
It
covers
goes really to the fee issue, but I thought we remedied this issue by suggesting that I think there's language that's been incorporated that perhaps it's in the draft.
produce them later.
Produce them within 14 days of having entered into them.
What I'm submitting is, we should never have to produce them.
Well, no, I understand, but understand also that you've hit the nail on the head, that producing the contract was, the genesis of that is on the fee side. Because that goes back to the Harrison County fee schedule that Doddridge County so far has been utilizing. And that's the only reason that Doddridge County, and it went back to I hate to go back to the litigation, and I might say that both of you have acted admirably and honorably to talk about each other and talk about that case so freely, Ms. Huff and Steve, without clashing in a negative way, because I think it's all been positive and productive. But
well, but if we do away with the fee, if we take care of the fee issue, the contract issue is really not an issue.
right.
But even if there's a fee issue as to the value of the project, you still need the contract to do that. You can have a...
Well, what I was going to say is it went back to the initial application that was filed in the Huff case, where someone came to the conclusion that the development was worth $40,000, which obviously the construction that was going to go on there was more than that.
Well, not to use legal words and semantics, it was the cost of construction was $40,000. There's a question of what construction actually is in the drilling of a Marcellus well pad. I mean, we could debate that. We don't need to do that here.
Yeah, I understand.
But all that being said, the permit application itself, if you're going to do over a certain amount is a maximum fee, then that can be taken care of that way by submission or affidavit or signature. But if we have a flat fee for a Marcellus well pad or oil and gas development or whatever it is, it's still not an issue for fees.
Yeah.
So the production of contracts have a lot of things in there that really aren't necessary for technical review by Mr. Wellings. It can be taken care of by filling out a line. And I believe, with all due respect to people in the room, that number was placed in there by a former county commissioner.
What number is that?
The $40,000 number in that permit.
Okay.
I believe.
No, I wasn't suggesting that you all did it. It's just
No, I
There's a
know.
belief that the total construction cost was way in excess of that number. And I understand that you might argue as to what is the construction cost, et cetera. On the fee issue, I mean, I'll state for those who don't know, there was a bill introduced in a committee at the legislative process this term, and I know you're familiar with it. And there was some back and forth between industry and the county commissioners association, and there seemed to be, and not that it's precedent or any precedent of an agreement, but there seemed to be an understanding that both sides could live with language that the floodplain permit fee shall not exceed $5,000. And I just throw that out as what I thought was potentially an agreement between industry and the County Commissioners Association at the time. Do you know whether, for example, Wafonga still stands by that type of understanding?
I think that I would, I am familiar with all that, but since Mr. Wondorf is here on behalf of
I
Wafonga.
was familiar and we're part of that negotiation.
Yeah.
We never ultimately.
You didn't shake hands on that?
No,
become
that
part
was
of
an
the
agreement, that was part of the verbal discussion.
Yeah, it was discussed.
Where we left that off was what we would take up the issue this summer and discuss ways.
In interims?
No, it wasn't part of an interim study, but between the associations, between the county officials to standardize these types of floodplain contracts or ordinances, so we wouldn't have to take this type of argument in every county that we have.
Well, I do. I understand that. And it does make sense. We have 55 counties, why would we have 55 different fees?
This is not the only county we've had to deal with it.
Yeah.
And what the way we see happening in the future is we're going to have to do this in every county that we have operations in.
Well, let me ask you this, both of you. And I have not worked with this fee schedule. I know Mr. Wellings has. This appears to have been a fee schedule that was promulgated in Harrison County, and like in many things, you take something from rather than recreating, reinventing the wheel, you take some suggestion from another county. Has anyone contested this fee schedule out of Harrison County, to your knowledge?
No, in fact, we have a memorandum of understanding with Harrison County that all our pipeline crossing, we have a pipeline crossing for all our, we have a floodplain permit, but we have a memorandum of understanding that we comply with certain provisions, and therefore the floodplain manager allows us to cross. So we were part of the negotiation.
Okay. Yeah, thank you.
Which I guess on a specific comment on the pipeline issues, we talked about that earlier, the practical impossibilities, quite frankly, of permitting pipeline over everywhere. I mean, I understand what FEMA requirements are, but you guys need to think about that. We probably need to suggest some language or limitations on what notice for pipeline, permit applications, what fee, waivers, and things like that would be, potentially. There are two other issues with the contract. We do not have a problem with providing information that our contractors are licensed. If you think people are doing work in Dodge County, that's okay. So if you want to make that a requirement, there's no problem showing you that. That's the purpose of the contract. The floodplain ordinance does allow and contemplate work by an unlicensed contractor. I'd submit to you that Dodge County should not accept that. I would submit to you that all contractors should be licensed, whether they're doing something on your home or not.
Yeah, but that, I didn't draft that part of it, but I did read the code sections that were referenced from whoever drafted it. And there are a bunch of exemptions from having a contractor's license. And when I read it, it made sense.
But they can be more restrictive. I just pointed out that that doesn't really matter to me because we use licensed contractors.
Yeah, but basically the way I read all those exemptions is that there was an overall bill that said all contractors have to be licensed, and then you get this certain group going down and say, why do we need a license because we're an educated engineer or something. I mean, there's a list of about 13 things that someone went and lobbied for to get an exemption from licensure. And it makes sense to me that if it's statutory law within the state, that it's fine with the county. those
Get a
entities.
license unless exempted.
Yeah, I mean, that's what I think. I mean, it may be in there. We have professionals. I think we have that language in one of the drafts that says if a certification or license is required by the state, you have to have it. We put that in there, I think.
Yeah.
We need to double check. I think that language is in there, which should be acceptable. The next